Hello and welcome to this bite-sized revision video from Now Training on the GDPR exemptions. Most of the requirements on how to handle personal data under data protection law are detailed in the GDPR. However, there's some finer detail in certain areas, including the exemptions to GDPR, that are outlined in the Data Protection Act 2018. The specific exemptions we'll be discussing in this video can be found in the DPA 18 Schedules 2, 3 and 4. These are all at the back of your GDPR handbook for your reference. The way to approach the exemptions is to remember the general rule that all the requirements of the GDPR apply to all personal data. However, the DPA scopes what parts of the GDPR you are potentially exempt from and in what circumstances. Most of the exemptions apply to the data subject's rights, but some might even apply to the principles themselves. As we work our way through the exemptions, you'll notice the ones towards the front of Schedule 2 scope a lot of the GDPR for potential exemption. Then as we work our way to the back of Schedule 2, you'll notice less and less. So let's start with Schedule 2, Part 1. Here you can see that this particular part starts by listing the provisions of the GDPR. That's quite a lot. So there's quite a lot of things you could potentially exempt yourself from transparency through to purpose limitation and all the data subject's rights, including Principle 1 and Principle 2. If complying with any of these would prejudice your ability to do one of the things we're about to talk to now, you could potentially use this exemption. So for the purposes of Part 1 are crime and taxation, risk assessment systems for crime and taxation, immigration and disclosures required by law. So for crime, would complying with the GDPR rights and obligations prejudice an investigation of a crime or delivery of justice? This used to be known as Section 29 requests if you're used to working with the police under the old law. Notice that this exemption also covers taxation. This includes local taxes such as NNDR and council tax. Risk assessments, similar to those above, but are more focused on the support of crime and taxation. Immigration, would it prejudice the government's ability to maintain effective immigration controls? And disclosures required by law, would complying with the GDPR affect your ability to legally disclose data as part of a court order, for example? Schedule 2 Part 2 is similar to Part 1, but notice that Principles 1 and 2 have been removed. Therefore, it's just the rights and principles as they relate to the rights that you're exempt from. Things included in there include functions to protect the public, so holding counsellors to account on a code of practice, for example. Audit functions, the functions of the Bank of England. Regulatory functions regarding your legal, health and children's services ombudsman. Other regulatory bodies like the ICO, for example. So if complying, for example, with a subject access request would affect the ICO's ability to investigate a matter, then it could be potentially exempt, as an example of other regulatory bodies. You've also got parliamentary privilege, judicial appointments and independence of proceedings, Crown honours, dignitaries and appointments. Again, if I take the example of a subject access request, if honouring the request would prejudice my ability to maintain parliamentary privilege or a Crown honours list, then I can look to exempt it. Schedule 2 Part 4 only scopes transparency and access for these purposes, and these include legal professional privilege, so legal advice from a certified lawyer, any information that would self-incriminate you, except where it incriminates you into a breach of data protection, aspects of corporate finance, management forecasts including details of restructures, exam scripts and exam marks, especially where it would compromise the integrity of the exam, confidential references, and negotiations. The journalism exemption in Schedule 2 Part 5 states that if complying with any aspect of the GDPR would prejudice these purposes, which cannot be private projects, they have to be with a view to publication, then you can look to potentially exempt yourself from the GDPR requirement. So this includes journalistic purposes, academic purposes, artistic purposes and literary purposes. Part 6 scopes access, restriction, rectification, objection are all in scope for the purposes of research and statistics. This is only where the research, for example, is in the public interest and is subject to other codes of practice and on scientific research, as an example. Another part of Part 6 scopes access, ratification, restriction, notification to others, portability and objection in scope for the purposes of archiving in the public interest. Schedule 3, however, works in a different way. Here, rather than the purpose for the data, Schedule 3 talks about the data itself instead. Specifically, health, education, social work and child abuse data. If you have anything that would be defined as health data, an educational record, a social care or child abuse records, data, then this exemption could potentially apply. Schedule 3 scopes out all the rights for potential exemption if the following grounds are met. Exemption of any of this data is subject to a serious harm test, based on the opinion of the relevant professional. This ideally has to be the most recent professional to work with the data concerned, or, if not, then a professional best placed to give a professional opinion on any harm the data may cause. The serious harm test is to determine if actioning any such rights requests is likely to cause serious harm to the physical or mental health of the data subject or another individual, a carer or someone else with the legal power to ask for such data on behalf of the data subject. This data also includes any of the data types processed by a court, is data about a young person requested by someone with parental responsibility, or where the person lacks capacity and someone manages their affairs. This may also take into account the data subject's own wishes where practical and appropriate to do so. Schedule 4 also talks about the data types and refers to types of data that are likely to have other areas of law governing them, especially those who can and cannot see them. These include human fertilization and embryology, adoption records and reports, statements of special educational needs, or parental order records and reports. Remember, for any exemption you look to apply, ensure you have proven and documented the prejudice that honouring that request would mean to your purpose. Otherwise, your exemption may be proven inappropriate in a complaint or appeal. Thank you for watching this bite-sized revision video on the exemptions to GDPR.